Shri Sudhir Kumar Singh contends that by virtue of the provisions of Section 55 of the 1965 Act, whatever benefits are available, the acquisitions under the Land Acquisition Act, 1894, the same would automatically be available to all such acquisitions under the 1965 Act, full stop. He submits that since the 2013 Act refers to the provisions of 1894 Act and the acquisitions made thereunder and is a beneficial piece of legislation for farmers, then by adopting the analogy of the latest apex court decisions, the provisions of the 2013 Act should also be read as extending benefits to the acquisitions made under the 1965 Act, full stop. In the event such an interpretation is avoided, the same would result in discrimination and will violate Article 14 of the Constitution of India, full stop. The contention, therefore, is that Section 24 in bracket 2 of the 2013 Act and its implications are also clear available to acquisitions made under the 1965 Act under Section 28 and Section 32 thereof, read with Section 35, full stop. Shri Singh has been invited the attention of the court to the decision in the case of UP Awas Evam Vikas Parishad versus Janual Islam and another, reported in Air 1998 SC 1028 to urge that in that case also where the matter relating to payment of higher compensation arose, the same was interpreted in favor of the tenure holders so as to include the subsequent amendments that were brought about in the 1894 Act to pay higher compensation, full stop. He, therefore, submits that discrimination was clearly the issue that was resolved therein, and it was held that the compensation payable for acquisitions under the 1894 Act would be directly applicable with all its subsequent amendments in relation to acquisitions under the 1965 Act, full stop. It is in this manner that in legislation was interpreted to be a beneficial piece of legislation and was, therefore, extended in order to avoid discrimination, full stop. Such analogy should also be applied in the present context of the applicability of the 2013 Act, full stop, para. He has then invited attention of the court of the decision of the apex court in the case of Nagpur Improvement Trust versus Nipendra Kumar and others, Air 2002 Supreme Court 349, to contend that here also the apex court had ruled adopting the reasonings of Janul Islam's case to hold that by virtue of Section 55 of the 1965 Act, amendments that were brought about in 1894 Act will also be treated to be incorporated for the purpose of extending benefits of higher compensation, full stop. He submits that such a construction would be leaning in favor of the constitutionality of the provisions of 1965 Act, or else, as in the present case, it would result in repugnancy, full stop. He submits that different principles of compensation cannot be adopted for the purpose of extending such benefits, which issue was also dealt with in the Nagpur Improvement Trust case in para 54 thereof, and he has then relied on the analogy that has been drawn for extending the benefits of the 2013 Act in certain contingencies to the aid of tenure holders, full stop, over.